All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature located on the right side of your WebEx window. We will do our best to get to everyone's questions. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down as it will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees following the presentation. At this time, I'd like to turn the program over to Dan Klein. Dan, you may begin.
Thank you. Welcome, everyone. We hope that we will move through this material in a somewhat rapid pace and leave time for questions at the end. So let us first introduce ourselves. I'm Dan Klein, a partner here in the Boston office of Seyfarth. And joining me today are Christina Duzlak and Molly Mooney, associates here in the Boston office. We're all in the Labor and Employment Group and have all been deeply involved in Massachusetts paid family medical leave advice and drafting and all the lovely things that many of your companies have been dealing with for the last year plus, and now as we gear up for January 1st and the implementation date. So let me just give you a sort of roadmap of what we're going to cover for the next 60 minutes or so. First, we'll just give a pretty short update on some of the final changes to the regulations, highlight some of those more important changes. We will spend a little bit of time talking about the interaction with other leave laws and employer-provided leave policies, where those both overlap with PFML, because that has been a very common issue of question and concern and frustration at times by clients. And there's some confusion in the language in the regulation. Then we will also talk about some other common issues and questions that you'll want to address now as you gear up for January 1st. Then we'll talk a little bit about, and just sort of a reminder and refresher of how the claims process is going to work, at least under the public plan. And if you're under a private plan, it should be similar once the claims do start coming in 2021, and the timing for the claims process, et cetera, and, as well as the appeals process, both for the public state plan as well as private plans. And then lastly, we'll just run through some other employer obligations to keep in mind as you finalize your policies and plans for 2021 and going forward. We will leave time for questions at the end, so please submit them under the Q&A platform here. If possible, try to wait to submit your questions, because we may actually address something and then we'll be trying to quickly get through the questions at the end. So to the extent we have to filter through questions that we've already answered, it may just slow things down and prevent us from getting to all the questions, but we will aim to do so. Why don't we start off before we do a quick refresher of what PFML covers. We wanted to launch this poll just to get a sense for the participants on this call, what type of plan your company is using. Are you under the public plan fully? Are you using some hybrid of either public plan for family or medical and private for the other? Or are you fully private and either under choice C, using a fully insured private plan, or D, a self-insured private plan? While those responses come in, I'll start with our little just refresher. I'm sure most of you have this by heart, but just as a quick reminder, and we won't spend the day going over all of the reviews of prior content we've shared. What does PFML provide here in Massachusetts to covered workers as of January 1st? Well, as you probably know, it provides 20 weeks of paid medical leave. That's job protected, similar to federal FMLA, and paid under the state formula, which is capped at $850 a week currently. That cap may change year to year. And then a private plan has to provide at least the same or better benefits than the state provides. So as of January 1st, medical leave will be in effect, and they can take up to 20 weeks in a 12-month year. In terms of family leave, there's various buckets of family leave, pretty much parallel to the federal FMLA. For family leave, it's up to 12 weeks per year of paid family, job-protected family leave. All of these reasons listed here take effect January 1st, except for one, and that's the first one listed here. An employee who's taking leave to care for a family member with a serious health condition that one will have a 6-month delay. That was sort of the phase-in of the law. That's the one phased-in part. That will take effect July 1st of 2021. But all the other forms of family leave as well as medical leave will take effect January 1st. And so those other forms of medical leave, as you have here in the slides, bonding with a child, so bonding leave for both mom or dad, and that's by natural birth, adoption, or foster care, the various family, military types of leave, qualifying exigency leave, as well as seriously injured or ill, injured service member leave. Those will take effect January 1st. Other than injured service member leave, all of those family leaves have a max of 12 weeks. And like the federal FMLA, the injured service member leave has a one-time use of up to 26 weeks of leave. And then combined between medical and family, there's an aggregate max of 26 weeks per year. So it's 20 weeks of medical, 12 weeks of family for the most part, and a total combined max of 26 weeks. So just getting a taste of where each of your companies are at, we see from the poll results, looks like 45% are on a fully public plan with the state. We've got 11% of you that have some form of hybrid, because you could do public or private with either medical or family. So some form of hybrid, 11% of you responded. And then for those of you fully private, 25% of the group have fully insured private plans, and 16% of the group have self-insured private plans. So if you combine the two together of those last two answers, you're looking at 41% that are on a fully private plan out of those responding, 45% on a fully public plan, and then 11% with some mix. So it's a pretty interesting and telling mix. With that, we will dive into some of the final regulation updates, and I will turn it over to Molly.
Thanks, Dan. Yeah, those poll results are really interesting. It's pretty cool to see such a nice mix of what people are doing as we head into 2021. So as Dan mentioned, we want to highlight some of the important changes that the final regulations made to the PFML law over the summer. And we won't really dig into all of those, but there are a few important ones that we think are worth noting here. So over the summer, the DFML issued proposed amendments to the regulations and then issued those final regulations in August. So the first important change really relates to the anti-retaliation provision. And under the prior regulations, this had caused some concern for employers because essentially it provided that any negative change to an employee's seniority, status, benefits, pay, or any other term or condition of employment within 6 months of returning to work from a PFML leave would have been presumed to be based on that covered individual's use of leave. So that's a pretty strong presumption of retaliation there. So in the final regulations, they revised this provision to provide an exception to the presumption. And essentially, it clarifies that a negative change shall not include trivial or subjectively perceived inconveniences that affect de minimis aspects of an employee's work. So obviously, this still leaves some room for subjectivity regarding what is trivial or de minimis, but it's certainly a better standard than the general presumption of retaliation for any negative change. Essentially, under the old regulations, any potentially negative change, even neutral changes that were perceived to be negative by the employee could have been considered retaliatory. So this is a welcome addition to the regulations. So moving on to the next slide. The final regulations also revised several provisions relating to the use of intermittent leave. So under the prior regulations, employers could set the minimum interval for intermittent leave essentially at whatever they wanted as long as it was 4 hours or less. Now, the regulations clarify that employers must set intermittent leave intervals consistent with what is available under other types of leave. So this is really similar to the FMLA. But the DFML clarified that they're not going to pay for increments of less than 15 minutes. The other point that they clarified is that they're only going to start paying for intermittent leave after an employee has accumulated 8 hours of intermittent PFML leave, or unless 30 days have passed since their first use of the intermittent leave. And now we're going to pass it over to Christina to talk about the changes to the regulations with respect to former employees.
All right, next slide. All right, hi everyone. So the regulations also clarified an issue regarding former employees under a private plan. So you might remember that under the PFML, former employees who have been separated from employment for less than 26 weeks and meet the requirements, they can apply for benefits. So a former employee that is under a public plan, they'll just apply with the state. Now, if a former employee was under a private plan, where they apply will depend on whether or not they're currently employed. So if they remain unemployed when they at the time of their for benefits with the former employer, and then if they become employed, they will submit an application with their new employer. So this prevents a scenario where an employee switches jobs, but then says, they're within 26 weeks of working for the previous employer, and they could say, well, there's better benefits from that former employer, I can apply there. So that just cuts that off. And then just also a new employer can require an individual to provide verification of wages in Massachusetts so that they can determine that an individual is financially eligible for PFML benefits. And next slide. So then the final regulations also added language regarding substance use disorders. So now they may qualify as a serious health condition. So this means that medical or family leave may be taken to obtain treatment or to care for a family member who is obtaining treatment from a healthcare provider. So the final regulations, they actually distinguish between leave for treatment and absence because of substance use. So as you see here, an absence because of an employee's use of a substance does not qualify for leave. Now, the final regulations also establish protections related to substance use treatment, as well as guidance regarding when an employer may take action against an employee for substance use that violates an employer's established policy. So basically what that looks like is if an employer has an established policy that is applied in a non-discriminatory manner, and that policy has been communicated to all the employees, and the policy allows for the employee to be terminated for substance use under certain circumstances, then pursuant to that policy, the employee may be terminated whether or not they are presently taking leave. But the employer may not take action against an employee because he or she took leave to provide care for a covered family member receiving treatment for substance use. Next slide.
Okay, so now we want to talk a little bit about the interaction between PFML benefits, whether you're under a public plan or a private plan, and other leave laws and other company-provided paid leave under other policies. And this is sometimes, like I mentioned earlier, a source of some confusion over the course of the various changes to the regulations. So let's first start off with the public plan. If you're under this state-provided benefits plan, PFML through the state will run concurrently with FMLA, Massachusetts parental leave, sick leave, vacation, compensatory time, regular paid time off, short-term disability, and really any company-provided paid family or medical leave benefit that's taken for a PFML qualifying reason. So generally speaking, any of these other types of paid leave, if they are for a PFML reason, it will run concurrently with the state-provided PFML leave and therefore run the clock against the 12 weeks or the 20 weeks or the combined 26 weeks. The time taken and paid through the leave under those other either statutory or policy-provided leaves will count towards that allotment, like I said. However, the company's policies that provide those other types of leave, whether it be your short-term disability policy or plan, whether it be a paid parental leave policy that you may have that is in addition to the public PFML or more generous, or any other paid type of policies, PTO, et cetera, it does need to notify employees that it will run concurrently with PFML when for a PFML covered reason. So your policies, if they haven't been amended effective January 1st of 2021, you should make sure that that language is in there and revise them. It's a very slight change, but revise them to notify employees that where the reasons overlap, they will run concurrently against the PFML allotment. Relatedly, and we're still talking about the public plan, the regulations speak of offsets of when are PFML benefits from the state going to be reduced or offset by other paid leave. And there's different results based on the different types of paid leave. So as you may recall, and this piece isn't new, this was in the original statute and the original and various versions of the regulations, but it does get confusing, so it bears refreshing and clarifying. For long-term disability, short-term disability, and any other type of family or medical leave type of policy, so like a parental leave, like another form of medical leave, any other company-provided family or medical leave type of policy, those may be taken at the same time by an employee to supplement each other. They may take PFML and have some income coming in from those other sources, and they will run concurrently, but they may actually collect from both at the same time. That's not going to be the same, as we'll talk about in a moment, for accrued paid leave. While we're on the topic of these other sources, though, so your short-term disabilities, your long-term disabilities, and your other family or medical types of policies, there's a little bit of nuance difference in how they offset. So we just wanted to remind people of that. And that's in the bullets that you see here underneath the second bullet. For long-term disability, unemployment, SSDI, and workers' comp, the state is going to automatically offset from the PFML benefit the amount an employee is receiving from those sources for the same leave. So even if it comes off the $850 max PFML benefit, so to speak, that will automatically offset from what the state pays and will reduce the amount the state pays. It's a little different for the other types of leave in this group. So for short-term disability or the other company-provided paid family or medical leave policies, such as parental leave, et cetera, those will offset, but only once an employee gets up to 100% of their average weekly wage. And in other words, that's another way of saying that short-term disability, paid parental leave, or any other type of paid family or medical type of policy provided by the company can supplement the PFML to get an employee up to 100%, can top off. The employee will not get more than 100% of their pay. The state won't pay it, and the employer need not pay it. What is important for your policies, and we'll talk about this again later, but I just want to touch on it while we're on the topic here. Your other company policies of short-term disability, paid parental leave, et cetera, the language in that policy should say, and if it doesn't, you should tweak it to say that you're going to offset the amount that that policy pays out by the amount of PFML available to the employee or that the employee is eligible for. And that way there's no question that whether they file for PFML or not, you are telling them that you're gonna reduce the amount of short-term disability or paid parental leave, whatever it is, by the amount that they are eligible for in PFML, and then hopefully that drives them to go file for PFML with the state, and together they'll get 100% of their pay. But because employers can't require an employee to go file with the state for PFML, this is an indirect way of incentivizing them to not only go file, because you want them to run concurrently and to exhaust both, but you don't want to be paying out all of your 100% paid parental leave if the state's going to pay part of it through PFML, or be paying whatever your short-term disability pays if part of it may be paid by the state PFML. So your language in that private policy should just say that it will be reduced by the amount of other state-provided paid leave benefits for the same absence for which the employee has available or is eligible. And then, as I said, there will be an offset once you get to 100% pay. Okay, so what about accrued paid leave? And this is where there's been a lot of confusion and questions as the regulations change the language in this provision several times. And we're still, at this point, talking about if you're under the public plan. We are going to talk about under a private plan next. So, unlike short-term disability and long-term disability and paid family and medical leave type of policies, PTO, vacation, sick time, comp time, personal time, those are not paid family and medical leave types of policies. Those are other types of paid time off. And that's been defined in the regulations as quote-unquote accrued paid leave. And it's treated differently than paid family or medical leave policies. So with accrued paid leave under the public plan, there's a difference. An employee can choose to use either or. They can either choose to use the accrued paid leave, which may be more generous if it pays out 100% pay, for instance, with their PTO or vacation, or they can choose to file with the state for the PFML benefits for when it's a PFML absence. However, the employer cannot require an employee to apply for PFML, as I said earlier. So they can't require the employee to use PFML instead of accrued leave, and vice versa. The employer cannot require an employee to exhaust accrued leave before they go to PFML or to file for accrued leave or PTO, et cetera. The employee has the right to choose. But when they choose for accrued paid leave, it's an either or under the public program. An employee cannot supplement, they cannot top off PFML with PTO or other accrued leave. It's a one or the other. They're either getting the state benefit and that max of $850 a week or whatever it ends up being in a given year, or whatever their PTO or the other accrued leave provides them, which may be 100% pay, it may be something else. It's an either or choice for the employee. And that's different than when we talked about short-term disability and all those others. For accrued leave, public program, either or, employee's choice. Collect the PFML or collect the PTO or other accrued leave. Either way, as we mentioned earlier, they will run concurrently against PFML allotment because they will get the job protection even if they choose to use PTO or other accrued leave. So it will run against their state PFML 12 weeks, 20 weeks, 26 weeks, even if they're choosing to get paid by accrued leave. But they are getting the job protection of the law, and therefore it is going to count against their allotment, and they will run concurrently, as we mentioned. Again, your policies should notify employees of this, and there's a requirement of that. It's a must that you must notify employees that if they choose to take that accrued leave for a PFML qualifying reason, for the same absence, it will run concurrently under PFML, even if they're not receiving the PFML pay directly from the state. So what does that all mean for private plans? And this is where we've gotten a lot of questions in the last few months. On that language we just talked about with accrued paid leave, that's where it gets funky. So let me just first address the first bucket of leave: short-term disability, long-term disability, workers' comp. All of that's the same for a private plan. PFML under any of these types of leaves will run concurrently under PFML and FMLA, mass parental leave, short-term disability, company-provided paid family medical, and the accrued paid leaves that I mentioned and we're going to talk about in a second. But for offsetting, short-term disability, long-term disability, workers' comp, unemployment, SSDI will operate the same for a private plan as it does for a public plan. It will you can, if you choose to, as you're under your private plan, you can choose to offset and deduct from your PFML the amount the employee is receiving for the same leave under LTD, workers' comp, unemployment, SSDI. For STD, like we said, for the public plan, you can offset once they get to 100% of pay, and therefore they can supplement your private PFML with your private short-term disability to get to 100% pay, but no more than that. Now, if you're self-insured, that may be meaningless. It may just be which bucket of you're taking it from, if you're self-insured for both. But if you're insured, it may matter. You may have self-insured short-term disability that's paying a portion. You may have fully insured PFML that's paying a portion to get to the employee to 100%. So it may differ depending on your sources for each of these. So the real question is the accrued paid leave under a private plan. What does that mean for private plans? Can employers allow in your private plans employees to choose, like they do under the public plan, an either or of the private paid family medical leave or what might be a more generous accrued paid leave, PTO, vacation, etc.? Is it an either or under a private plan, or can an employer in their private plan allow employees to top off and use both and add to their PFML under the private plan their PTO to get to 100% pay or vacation, personal time, etc.? It's not crystal clear in the regulations. They don't really address it for a private plan. They don't necessarily prohibit it, but they don't necessarily say that the same rule for public plans doesn't apply to private plans. We've talked at length with a number of clients, and if you look at the language of the regulations, that section is entitled state-provided benefit. So there's an implication that maybe that rule of the either or really only applies to the state plan. And then there's the general rule that for any private plan, you can provide equal or better benefits to employees. So this is a more generous benefit if you're allowing them to top off. You're not harming the employee in any way. You're not taking away PFML in any way. So based on all that, we've sort of come around to being comfortable saying that until the department clarifies further, it's probably low risk if you want to have a private plan that allows employees to top off their PFML with other accrued paid leave. However, it should be the employee's choice. We don't think you're safe to require it and make it mandatory. You can't require them to top off PFML with that PTO. That would be dangerous. But we think you're probably safe for now, without clarification from the department, to allow employees to choose if they want to top off the private paid family medical leave with other accrued paid leave. Either way, they will continue to run concurrently, and either way, there is a requirement that in your policy you inform employees that they will run concurrently. And I would just say that with that, keep in mind that if the employee is choosing, what I was going to say is we have checked with the department. We just haven't gotten an answer. So they are basically not ready to take this question on. So stay posted. It may change, but until then, we at least know of several clients who are willing to take the risk because ultimately they're not harming the employee in any way. All right, so now I'll turn over to Christina to just talk about some other common issues and questions to address now as you're gearing up for January 1st.
Okay. So this is actually an area where we've received a number of questions, and the department actually changed its position on this topic in the last year. So as you can see here, any leave that a covered individual has taken for the same qualifying reason prior to January 1, 2021 is not going to count against their PFML leave allotment or their weekly benefit amount. This applies to both private plans and state plans. And so that's going to have some interesting implications, especially for individuals who have taken some sort of leave in 2020, but are still going to be eligible for leave in 2021. So we can go to the next slide. So there's a couple of scenarios that we want to run through that we've seen come up quite a bit. And so, for example, if an employee had a child on April 2nd, 2020, that employee could be eligible for 12 weeks of paid family leave from January 1st, 2021 through April 2nd, 2021. And this is even if they've already taken paid parental leave in 2020. And the reason for this is because the PFML law provides that bonding leave may be used anytime within the first year, the first 12 months after the birth, adoption, or placement of a child. So this employee in this scenario, from January 1, 2021 to April 2nd, 12 months after the birth, could take 12 weeks of paid leave under the PFML. And we have another scenario here of an employee who has given birth on December 2nd, 2020. And, you know, if they suffer complications, depending on the employee's healthcare provider, their assessment of her condition, as of January 1, 2021, she could be eligible for up to 20 weeks of medical leave for her own serious health condition, and then the 12 weeks of family leave to bond with her child. Obviously, this would be capped at the 26 weeks. But again, this is regardless if she's already taken leave in 2020. So any of the 4 weeks she took from December 2nd to January 1, that's not going to count against her leave allotment. And then the other thing to consider about this scenario is the amount of time that the employee takes to recover from childbirth. That's going to depend on her condition and the healthcare provider certification. So we're used to somewhere between 6 to 8 weeks for recovery from childbirth, but the law does not limit the amount of medical leave that can be used for recovery from childbirth beyond the 20-week medical leave cap. So if an employee experiences complications after birth, then her healthcare provider could certify her for longer than 6 to 8 weeks. And so employers should definitely be prepared for that. And then there's also a scenario where, a little bit different than this scenario, but after January 1, if an employee is about to give birth and has complications before the birth, that would also qualify for medical leave. So a couple of things to consider within that realm.
Sorry about that. So as this previous slide shows, the source of this was that in the changes to the regulations, the department said that in 2021 and going forward, if you have a leave that you took under another leave policy, et cetera, it's going to offset the amount of leave under PFML. And we asked this question actually back in May in the original about what about for leaves in 2020, especially parental leave in late 2020 that could butt up against 2021, especially with the same baby, the same leave continuing, and it could come up with other leaves as well. And the department initially told us that there would be an offset if it was the same cause of leave. And then they did a 180 in the final amendments to the regulations and put in this language that offset going forward will not apply to 2020 leave. And so that's where we've created this situation. All right. Molly.
Great, thanks, Dan. Dan, there's a box back again on the slide, just quickly. Okay, yep, it's gone. Okay, great. So Christina just covered the overlap of situations in which leave taken in 2020 and how that'll be impacted with the availability of PFML in 2021. And there are a couple of other situations that employers need to be aware of in terms of the overlap between PFML and other statutory provided leave. So the first is the Massachusetts parental leave law is still around. PFML does not displace it. It's still in effect. So the parental leave law gives employees 8 weeks of unpaid leave for the purpose of giving birth or placement of a child. And this leave will run concurrently with PFML benefits, but it's important to note this because if an employee has already exhausted their 12 weeks of family leave under PFML, say, for example, caring for a family member with a serious health condition, if they then need to use family leave for bonding or for any of the reasons that they could use it under the parental leave law, then they're also entitled to those 8 weeks of unpaid leave under Massachusetts parental leave law. This also can occur in the FMLA context. So if, for example, because the PFML does not have an hours requirement or service time requirement, employees are actually eligible to use PFML from the inception of their employment as long as they meet the financial eligibility test. So if you have a new employee who uses PFML early in the year, exhausts their PFML, but then has another qualifying reason for leave later that year, and at that point they qualify for FMLA, then they're going to be entitled to the unpaid FMLA leave at that point in the year because they weren't entitled to it earlier. So it's important to keep in mind that just because an employee exhausts their PFML, that doesn't mean that they aren't entitled to other unpaid leave under either the Massachusetts parental leave law or the FMLA. Next slide. Okay, so one of the serious things that we've been thinking about as we head into 2021 is COVID-19 and how that's going to impact the use of PFML as of January 1. So as of January 1, employees, if they contract COVID-19 and meet the definition of serious health condition, they're going to be eligible for up to 20 weeks of medical leave paid for their own serious health condition to care for those COVID-19 complications. Additionally, employees may be entitled to family leave to care for family members with COVID-19, but that won't be available until July 1st, 2021. So that one bucket of leave is the one type that's not available until July. So remember that a serious health condition is defined as an illness, injury, impairment, or physical or mental condition that involves inpatient care or continuing treatment by a healthcare provider. So COVID-19 and the various complications resulting from it could quite possibly qualify as a serious health condition. And another thing to keep in mind on this point is that former employees are also going to be able to use PFML benefits. So that's something that may happen as of January 1 when these benefits become available.
Hey,
One
Molly,
thing we also...
I'm sorry.
Go ahead, Dan.
I was just going to remind folks that the opposite may be true too of the prior point about COVID-19 meeting serious health condition. Because so many are asymptomatic or may have minor symptoms, it's not going to be automatic. And just because your employees come in and January 2nd and say I'm COVID-19 positive, I want 20 weeks of paid leave. It's not necessarily going to qualify as a serious health condition. It might, and for some it certainly will. But keep in mind, it's definitely not an automatic, especially with the way COVID-19 is.
Yep. Yeah, that's exactly right. It's a good point to make because the employee's condition has to actually qualify as a serious health condition. So either requiring inpatient care in a hospital or a medical facility or continuing treatment by a healthcare provider. And obviously, if someone is asymptomatic, they're not requiring that sort of medical treatment and therefore would not be eligible to take PFML for those purposes. So one other point we wanted to make about COVID-19 and PFML is that obviously this is new. So there's going to be a learning curve in terms of the DFML getting things up and running. We've already sort of seen that as the regulations have rolled out and we're preparing for this process. But if COVID-19 rates continue to rise, we could see a lot of applications for PFML leave related to COVID-19. And it could be that the DFML, as starting out brand new, trying to get a handle on things, they could be overwhelmed by applications for benefits relating to COVID-19. So we don't know what's going to happen, but we would not be surprised if we see sort of longer than usual wait times as we head into 2021. Next slide, please. Okay, so a few other things we wanted to flag just with respect to the intersection of COVID-19 and PFML. So as everyone knows at this point, the Families First Coronavirus Response Act is going to be expiring at the end of December. And that timing sort of lines up perfectly with when PFML is going to be available in the Commonwealth. So that is another contributing factor to the fact that we think that we're going to see a lot of applications for PFML leave with respect to COVID-19. And we also wanted to note that Massachusetts has been considering legislation to require COVID-19 related leave for employers with more than 500 employees because the FFCRA only covers employees with or employers with 500 or less. But that bill has been in committee since August, and we haven't heard any updates on that. So unclear if anything is going to happen on that front, but we just wanted to flag it. Next slide. Okay, so one other thing we wanted to cover here is we've sort of been in flux with everything happening with COVID-19. We have a lot of employees working remotely and a lot of people that are temporarily working in different locations. So during the state of emergency, it was clarified that an individual who previously performed services outside of Massachusetts and therefore was not eligible for PFML, they do not become eligible for PFML just because they're temporarily working from home in Massachusetts. So if someone usually works in New Hampshire 100% of the time, but is currently working remotely in Massachusetts due to COVID-19, and that's a temporary situation, they are not all of a sudden eligible for PFML. And the reverse is also true. So if an employee formerly reported into Massachusetts, to a Massachusetts office every day for work, but now they're working from home in New Hampshire or Vermont or another state, they are still subject to PFML because it's a temporary situation. And the key word here, we've underlined it twice, is that this is temporary. So if the situation changes, if an employer decides, you know what, this remote situation is working out really well, we're going to make this full-time moving forward, everyone's going to be working remotely, then there should be some sort of reevaluation as to whether employees are still subject to PFML or should be subject to PFML. Next slide, and I think we're going to do another poll question here.
Yeah, so the poll question we're launching now as we get into this topic is, has your company switched since this would be since October 1st of last year, 2019, have you switched from either the state public plan to a private plan or from a private plan to a public? It's just a yes or no question whether you've made any kind of switch. We know a number of companies that have done so. So the poll we launched, have you switched from state to private or private to state? Go ahead and launch that poll while we talk about this. So if companies switched, you are required to provide notice to employees. As you'll recall, back in 2019, you had to provide notice to employees of what type of plan you are going to provide. Now, if you're making the switch from public to private or vice versa, you may wonder whether you need to issue a new individual notice and obtain the acknowledgments. That process we went through last year, October 1st, 2019, where you had to send a notice to each individual employee and you had to get an acknowledgement back that they acknowledged receipt or declined to acknowledge receipt. Does that apply now if you're making a change and do you have to provide that notice? It's not clear. It's not addressed in the regulations of the statute or on the website or by the department. So the policy behind it of notifying employees that they're going to have a certain deduction taken or they're going to, knowing how to make a claim, you would think that they're going to need that information if you make a switch in your plan, and common sense would say that they should be notified of those changes. Is it technically a requirement? Not clear. The other question came up, can we provide the notice but not do the whole acknowledgement process that was such an administrative burden last year? And again, that's sort of just a balance of your risk tolerance that maybe you don't technically need to do it and it's too much of a burden. So there's no real answer one way or the other, and it really just needs to balance how easy it is. But I would say at least providing some notice of the change should be done. And if you're switching from public to private, you also may need to, you do not need to repay employees for the contributions that you previously withheld. Keep in mind that even under a private plan, employers can withhold contributions. So just because you were under the public plan, maybe took a contribution from the employees and you're now switching to private, you don't have to pay that money back to the employees because you could have collected it all along for private and you can still use it now towards your insurance premiums or your self-insured funds that you'll be using to pay benefits. If you're switching from private to public, however, the employer will owe the state contributions to the state trust fund retroactive to October 1st of last year, because the state now needs to know that if they're going to be paying out benefits from the trust fund to your employees, you have to have paid in back to the October 1st date of 2019. And looking at the poll results, it looks like 11% of you said yes, that you have done some sort of switch, while 86% of you have not. Okay. On the transition from public to private and vice versa, also just a few other quick things to note. An employer that does not intend to renew its approved private plan at the effective date of the termination of the approved period must notify covered individuals and the department no later than 30 calendar days prior to the effective date of termination. So if you're not going to renew after you've been approved, you have to provide at least 30 days notice, both to the individuals and to the state. If you're in the future are making any switches from public plan to a private plan after January 1st, and the switch takes place during an employee's PFML leave, the department, and again, this is where you're on the public now, the department will continue to provide the public benefits to that employee for the duration of that leave. Obviously, it'll change for any new leaves after the switch. For the opposite situation, if after January 1st you're switching from a private plan to the state plan, and the switch takes place during an employee's leave, then in that case, the company will be responsible for providing the PFML benefits for the duration of that leave, just as the state would have done in the opposite situation. We also wanted to note that for intermittent leave, you may be in the middle of an intermittent leave that the switch from public to private, from private to public takes place. In that case, where there may be an ongoing intermittent leave, the employer will be responsible for the remainder of the benefit year to pay for that intermittent leave under the previous private plan. Okay, our last poll question we're going to throw out there is, has your company revised its handbook or policies for the January 1st rollout? Have you made any changes as you gear up for January 1st? As we have you answering that, we'll move to the next slide and just talk generally, keeping in mind you may have done your notices last year. You probably, if you had a private plan, designed a private plan. If you're under the public plan, you have just sort of assumed that they've got the information they need from the notice. Do you need a policy? Should you change a policy? Do you need to adjust other policies in your handbook, et cetera, now that we're gearing up for January 1st? And we do think you should update your handbooks and your policies as you prepare for January 1st. Things to consider, language in your PFML benefits, language in your policies regarding PFML benefits running concurrently with other leave laws and other company-provided policies. We mentioned that earlier, that you're going to you need to notify employees that they will run concurrently. To the extent there's interaction between your other company-provided leave or short-term disability and the PFML benefits, those overlaps we talked about earlier, you're going to want to tweak those policies again to have an offset or a deduction for the amount the employee is eligible for under PFML. So make sure that language is in your existing policies or change them. And just generally be clear about when benefits are available. For example, PFML benefits to care for a family member's serious health condition are not going to take effect till July 1st. Make sure your policies are clear about that. But generally speaking, it probably makes good sense to have a paid family medical leave policy if you don't have one, especially under the public plan. Didn't want it last year to cause confusion, but now for January 1st, you should have one in place for December as claims may start coming in, just to remind people of the process. On the results of that poll, it looks like 36% of you have made revisions to your policies or handbooks, 60% of you have not. Okay. And with that, I'll turn it back over to Christina.
Okay, great. So applications are going to be available for state benefits starting on December 2nd, 2020. So there's nothing up on the website yet, so stay tuned. We'll get to see what the certifications look like and the applications. The regulations provide what is specifically required for these applications. One of the key things is that the employee has to provide notice of their leave to their employer prior to applying, and they have to provide proof of notice or their application is not going to be accepted. And this notice requirement, that basically the department's going to require the employee to comply with whatever the employer's usual and customary notice and procedural requirements are, absent any kind of unusual circumstances. And then covered individuals should submit applications for benefits at least 30 days in advance of the anticipated leave and no more than 60 days in advance. We're going to go to the next slide here. One thing that was added to the regulations is that employers may submit applications for benefits on behalf of covered individuals, but they need approval from the department first. So it appears that this change may permit employers to submit applications for claims on behalf of an employee for a qualifying leave, even when the employee doesn't desire to do so. I mean, it's not specific in the regulations that state this, but there's nothing that in the regulations that says that can't be the case. And we think this could actually help employers with their own paid family or medical leave policies to prevent abuse and force state contributions to offset the company's paid leave benefits. Next slide. So we're gonna, because we're at 151, we wanna get some questions. The only thing I wanna say about the appeals process is that if you have a private plan, this needs to be added into your private plan. So we've provided the requirements here for the appeals process for both the private plan and the state plan, and you should feel free to reach out to us if you have any questions.
Okay, we do want to leave enough time for questions. So the remaining slides really speak for themselves. They're just a little bit more content on, as Christina mentioned, the appeals process, as well as employer obligations in terms of deadlines through that process and with your respective plans. We won't spend time talking about those because we do want to give you time for questions. And then lastly, we have a slide about some thoughts on training managers just to make sure they're aware enough to direct people to HR or to your leave administrator, as well as understanding the anti-retaliation provision. I do want to provide the CLE code at this time, and then we'll open it up to the questions. It is SS as in Seyfarth Shaw 6641. Again, that's SS as in Seyfarth Shaw 6641. So let's see, we've been getting questions. We've got some time here.
Just as a note, yes, we've gotten a number of questions about whether we're going to be sharing the presentation. Yes, we will be sending this around within the next day or so. So you guys will all have access to these slides.
Okay, so there was a question about whether surrogacy would qualify as a bonding leave. Are they able to take PFML to bond for surrogacy? I believe the answer to that would be yes. I don't know, Christina or Molly, if you have any different thought on that.
Yeah, that's right. So the language of the regulations say that they can use family leave, a parent can use family leave to bond with their child. So it specifically says adoption and bonding with their child. So for surrogacy, obviously that's their child. I would assume that that would be covered.
Another question we had, many private plans will allow employees to be made fully whole if the employer wishes via use of sick leave or PTO. Is it true that the state plan will reduce or offset benefits for other income received? Okay, so that question may have been asked before we spent time on that. Again, there is not an offset for sick leave or PTO under the state plan. It's an either or, and you cannot collect from both under the state plan. Okay, can employers now require employees to use earned sick time leave concurrently with PFML if for a qualifying reason? I believe this is a change from prior versions of the regs, someone mentioned. Molly or Christina, you want to take that one?
Sure. So employers, my understanding, and Dan, jump in if you have a different one. My understanding is that employers cannot require employees to use earned sick time, but employees can choose to do so. And if they choose to do so, they cannot use PFML at the same time, but they will run concurrently.
That's right. And the typical overlap would be in that first week of PFML. The first week of PFML counts as PFML because of job protection, but it's unpaid. And the assumption, I think, from the state was that employees, if they have it available to them, will use their 40 hours, if they have it, of earned sick time to pay for that first week of job protected unpaid PFML. But can the employer require it? No. It will run concurrently against PFML if they take it, but you cannot require use of earned sick time. Okay, a few more questions. Someone asked, so an employee cannot use PTO to get to 100% pay while collecting PFML. Okay, so again, for the public plan, the answer is the employee cannot use PTO to top off and get to 100%. For a private plan, it's unclear in the regulations. We believe you probably are safe to allow an employee to choose to use PTO to top off on a private PFML plan. You cannot require it, but you can leave it to the employee's choice. Again, that's not crystal clear, but it's our take on the current state of things until the department says otherwise. Another question.
Dan, there's actually, I was just going to say, there's another question further down that sort of goes right along with that. And the question is, would the state know if employers allowed employees to do that? And realistically, I don't think so. So that sort of goes right into that. And that's sort of why we think that it's probably something that we can do, but we just don't know for sure.
Yeah, it will depend on the forms. We're going to get the forms in December, supposedly, that the department's issuing. And well, I should say under the public plan, there will be a submission to the state at the outset of a claim where they will ask the employer for certain information, including if the employee is receiving any other income for that leave. But that won't be the case for a private plan, you're right. So under the private plan, it's not like the state's going to know if there's other payments being made during that leave. Okay, looks like we have a few similar questions on that. Let's move on to a different topic. If the employer has unlimited PTO, not accrued, is the employer required to make that available to the employee for use for PFML? So whether it's accrued or not, unlimited PTO is still going to be in that bucket that's defined as accrued paid leave. It's paid leave that is not a family type of leave policy or a medical type of leave policy. So under the public program, even unlimited PTO cannot be used at the same time as PFML. The employee has to choose. Now, you would think if it's unlimited and it's 100% pay, they're going to choose it. That's their choice. It will run up their time of PFML because they get the job protection, but it's an either or. And for the private plan, same issue we said before. Even if it's unlimited, we think that the employee could choose, but we don't think it's safe for the employer to require the employee to use the unlimited PTO to top off. You also don't really have a need to require it because it's unlimited anyway. It's not like you're getting some exhaustion of the unlimited PTO that benefits the employer. Okay, we've got another minute or two. The private plans using PTO, we've already covered that one. Let's move on to something else. Everyone's asking about my big gray box blocking the screen earlier. When you refer to offset and reduction, are you using those words interchangeably? Yes. I should say when I was talking of the offset or the reduction from PFML for LTD or short-term disability or other paid family medical leave policies, I do mean the same thing. And again, for the LTD, that is an automatic offset by the state, whereas for short-term disability and other paid family medical leave policies, it's only offset once you get to 100% of average pay. So that doesn't, the employee doesn't get a windfall above their 100% pay. Are there any special considerations for federal employers? I don't recall offhand. I don't know, Molly or Christina, if you recall the definition of covered employers, whether federal government employees are subject to this.
I'm not sure on that one.
I'm not sure.
We'll follow up by email
on that.
We're right up against the clock. We'll do one more. Are we on the calendar year leave for every year versus rolling 12? Does everything start on Sunday, et cetera? So the way that the regs and the statute are, the leave year, the 12-month leave year, starts on the Sunday preceding the beginning of leave, just to confuse things and make you all whacked out with your FMLA calendar year. So it's essentially a rolling 12 months going forward, but it's the Sunday before leave starts. Okay, we are out of time. We apologize that we didn't get to all of the questions. There are a handful more. We will respond to those by email. And thank you, everyone. Have a great day.